everyone. Sunita Malapati with the CACNA1A Foundation. Really appreciate you all coming today to learn more about estate planning for special needs, for the special needs community. And we're really grateful to have Kathleen Hayes here, and really want to do a special thank you to Teresa Spong and her initiative with Lynn Marino to bring together this resource for our community. And we're super excited to dig into the details. Before we get started, just a little bit of background on the CACNA1A Foundation. The CACNA1A Foundation was started in 2020 and really was an effort by Lisa Manister and other parents to come together to try to find treatments and eventually, we hope, a cure for kids and adults who are diagnosed with a CACNA1A related disorder. The CACNA1A is a one specific gene that helps neurons communicate with one another. And so a lot of our kids in the community and adults in the community have to deal with a variety of different neurological related disorders, including epilepsy, ataxia, which is a balance and coordination disorder, eye movement abnormalities, intellectual disability, autism. It's a range of conditions and symptoms that our families face. And unfortunately, right now, there are no specific treatment options for this condition. And so families are trying various medications with, some efficacy, but not as much as we would like to see. And so the foundation is really focused on accelerating research in this space, as well as supporting our families and raising awareness of this condition so that, we are all on this journey together, and hopefully, one day in our lifetimes, we will have treatment. So when future people are diagnosed with this disease, there's actually an actual treatment the doctor can prescribe, as opposed to what we're doing now. So really grateful for everyone here, your support, and we hope you get a lot out of this session. And with that being said, I'll toss it over to Teresa to introduce today's speaker.
Welcome, everyone. We are so fortunate today to have Ms. Kathleen Hayes. She is an attorney in Connecticut. And a special thank you to Lynn Marino for finding her and making all this possible. Our CACNA1A community crew is a group of grandparents and extended family that meet once a month. And this was a topic that came up of interest for us, and we felt like this was a great topic and would really benefit the parents in our community as well. So we've opened it up to extended family, everyone who might potentially have an interest. So Ms. Hayes comes to us with a very special passion for working with people with disabilities. She had an uncle who had intellectual disability, and this sort of formed her heart for the advocacy of working in this field. Kathleen graduated from Western New England University in 2013. And after she graduated, she clerked for 2 judges in the Connecticut Appellate Court. She also served as a special education attorney, advocating for the rights of students with disabilities within the school system. And I know that's a passion of a lot of our parents too. Kathleen later expanded her passion for disability planning into the realm of elder law and estate planning. So today I'm going to have her do her presentation, which will probably take about 40 minutes or so. If you have questions, I'm going to ask you put them in the chat, and she has time for us to go through those questions and ask questions at the end as well. But if you think of a question, just throw it in the chat, and then we'll cover all those at the end. So without further ado, I'm going to turn it over to you, Kathleen, and take it away.
Wonderful. Thank you all for having me. It's a true pleasure. I will just say from the outset, I'm getting over a cold, so sometimes that's the benefit of virtual, but just bear with me as I might cough my way through it just a little bit. I've got that, perennial tickle, but thank you very much, Teresa, for the introduction, and Lynn for the invitation. It is a pleasure to speak with your group today. My focus, I work in Glastonbury, Connecticut. My firm is really focused on special needs planning because of that passion that Teresa had mentioned in my personal family connection with disability. My goal in working with individuals and families is to help them to create more than just legal documents, but to kind of take a step back and more globally and more holistically look at what does life look like? How do we plan for and ensure, really even beyond the legal documents, for quality of life for a loved one with a disability, understanding that those needs are going to change as the individual ages, and that you're going to have to marshal in a lot of different resources, public benefits, legal planning tools, other individuals, and considering housing, transportation, what does day program or employment support look like? So these are questions that I'm sure within your home states, you or your loved ones are questioning and experiencing. And because you're a group of grandparents and extended family and friends, certainly within your own families, there's great fortune and blessings that there is that extension of family support out there, because it truly does take that network for individuals with disabilities. So this afternoon, I have the pleasure of presenting some general special needs planning considerations for individuals with any type of disability. And I will be focusing kind of on what the federal law will permit. So specifically focusing on ABLE accounts and special needs trusts, which the rules that I'll review should generally be universal across the 50 states. Noting that, of course, every state is going to have some individual complexities, but most of what we're talking about today is really governed by federal law, so that we can all kind of go and you can take this information to your family and be able to play with it. So with that, I'm going to share my screen. Great. Okay, so in general, special needs planning, it's a term that I'm sure you've all used. I'm sure you're all familiar with it. But in the legal context, special needs planning is really the process of preparing for the future of an individual with a disability. And it includes a variety of things, and those things are tailored to each individual's particular family structure and particular needs. It may include accessing public benefits. So going and looking at both the state and federal level at what kind of government supports are available to provide insurance or cash or other services and supports to an individual by creating legal planning tools to then protect those public benefits, and then planning for quality of life in general for the individual when the parents or the core family members are no longer around. And that's that really holistic and lifelong planning that I spoke about at the onset. So in general, what are public benefits? Public benefits are often also referred to as maybe government benefits or supports. They are state or federal or a merger between both the state and federal government programs that provide assistance in one of the following areas in general. And certainly there's a variety of public benefits available, and they can vary by state, and they can even vary, excuse me, by municipality. There might even be town-based supports and services that an individual can access, as well as services that an individual can access through nonprofit organizations or private organizations as well. So the focus is on state and federal programs that generally provide housing support. So usually that means housing subsidies that will help to offset an individual's rental liability. So at the federal level, there are things called housing choice vouchers, and maybe you've heard of Section 8. And the way that those programs generally work is that an individual typically pays 30% of their income for rent, and then the rest is covered by the subsidy. There are varying income and or asset limits that apply to those benefits, meaning that the individual has to have lower income and lower assets in order to be able to financially qualify for these housing benefits. There are food benefits. So SNAP is a federal program. That's what people commonly refer to as food stamps. So typically that's going to be a cash benefit paid to an individual each month to offset their food costs. And those SNAP benefits have income and or asset limits that are low depending upon the state that you're in. There are cash benefits as well, state-based cash benefits as well as federal cash benefits. So these are basically checks that are written to an individual to help pay for rent, to help pay for food, to help pay for general costs of living, because the individual has a disability that's otherwise limiting their ability to earn wages. So the cash support is generally coming in to substitute what the individual is otherwise unable to earn by virtue of gainful employment. And we are going to talk about today just the general rules of one of the federal cash assistance programs, which is SSI, Supplemental Security Income. There are medical benefits out there. So this is what people generally refer to as Medicaid. And Medicaid is a partnership between the state and the federal government. So there's going to be some overarching federal guidelines for Medicaid, and then there's going to be some specific state rules as well that you would have to consult locally about. But we'll talk in general about the Medicaid program, which generally comes with low income and asset limits. And those medical benefits are typically health insurance. So somebody that is no longer insured through a parent is possibly not working, so they're not insured through an employer. So it's turning to this Medicaid program for health insurance for somebody that has a disability or is otherwise low income. And lastly, personal care services. Personal care services often come through Medicaid, meaning an individual might need hands-on support. They might need services due to intellectual disability. They might need help with job support, for example. Many of these personal care services are provided through what are known as Medicaid waiver programs. Medicaid waivers are basically authorized by the federal law, and then the states go and they essentially adopt these programs, these services that are then offered to individuals. Sometimes there are waiting lists for these programs. But again, the entry is typically Medicaid, which has low income and asset limits. So these are all the variety of public benefits in general that an individual might need to access in order to support their core needs. Public benefits often have low income and asset limits, and so the outright receipt of funds may cause the loss of benefits. And I'm sorry, I have a settlement. I forgot to update this particular version. I was talking to some personal injury attorneys about this the other day, but the outright receipt of an inheritance, for example, as is most applicable here, or the outright receipt of a gift may impact these public benefits. And we'll talk about, just to kind of put a cap on this, we'll talk about the two different tools, ABLE accounts and special needs trusts, that can help to basically make those things, make gifts, make inheritances and things like that invisible, so that an individual can essentially have their cake and eat it too, meaning they can meet the low income and asset eligibility limits for these benefits while still being able to receive the benefit of those gifts and of the inheritance, for example. So this is that federal cash benefit that I mentioned earlier. So supplemental security income, SSI, is one of the most popular cash benefit programs that individuals receive. And in 2025, this is a cash benefit of up to $967 a week. In order for somebody to qualify for SSI, they must have a disability that's impacting their ability to work. That doesn't mean they're incapable of working and earning any wages. It typically means that though they may be working, they're not earning at such a level as to be competitively employed and to be earning wages that essentially would be sufficient for their own support. So the word supplemental, I typically say, is a supplement to wages that otherwise would be earned, but for a disability that's impacting someone's earning capacity. When you apply for SSI, there's a review of medical records, often educational records, all of those, if a child has been enrolled in special education, those neuropsychological evaluations, all those triennial reviews, they're looking at all of that medical documentation and things from an individual's physicians to determine, do they in fact have a disability that meets Social Security's criteria that's impacting the ability to be gainfully employed. And the financial component here is that the individual has $2,000 or less in their personal accounts. So that means a checking account, a savings account, a custodial account. So sometimes parents or grandparents set up a custodial account that ultimately becomes the individual's when they turn typically 21. All of those things count toward this $2,000 asset limit. So when an individual is enrolled in this SSI program, if they receive a gift or if they receive inheritance outright that now belongs to them, they're going to lose eligibility for this benefit. So what we'll talk about is the use of special needs trusts to enable this transfer of resources without impacting this. Just a note before I go ahead, there's another benefit called Social Security Disability Insurance, that's SSDI. SSDI is achieved in one of two ways, either through an individual's work record. So basically somebody has worked, they've paid into Social Security, and then a disability onsets, they're no longer able to work. So they apply to get their Social Security disability benefit based on their own work record. And it's a monthly benefit to them based on that work history or based on what they've paid in. For individuals with disabilities that may not have that work history, the other way to get that SSDI benefit is through what's known as the Disabled Adult Child Rule. So that rule says that if you have a parent that worked and paid into Social Security who goes on disability themselves or who is retired, that child will get 50% of the parent's benefit without reducing what the parent receives. When that parent passes away, the child will get 75% of that parent's benefit. The SSDI benefit is not means tested, meaning there is no $2,000 asset limit. So if someone's on SSDI and they're collecting that benefit, there may not be a concern about a receipt of an inheritance outright affecting that benefit, though it's important to look more globally and make sure that there aren't other benefits that would otherwise be diminished or lost based on that receipt. For that disabled adult child rule, a couple other facts about it. The individual's disability had to have onset prior to the age of 22. So with regard to this group in particular, certainly if a disability onsets at birth, then that would meet that rule, even if somebody doesn't apply for disability until after the age of 22. It's not your date of application, it's the date of onset of the disability. And the other rule with this Social Security disability disabled adult child benefit is that 2 years after getting SSDI, the child will get Medicare as well. So that again is not a means tested benefit, no income or asset limits associated with the Medicare. So understanding and consulting with local attorneys in terms of what benefits are available and making sure that you're really accessing everything and knowing that, hey, somebody typically is going to start off with SSI because they don't have a work history. And then over time, maybe when a parent retires or passes away, that child's benefit often will convert from SSI to SSDI. Medicaid benefits. So Medicaid is a source of both health insurance. So we were talking earlier about how somebody may need Medicaid because they're not insured through a parent and they're not insured through an employer. So they're accessing Medicaid as just their source of health insurance to pay for their prescriptions, doctors, and hospital visits. But it's also a source of personal supports and services, which is where we were talking about those Medicaid waiver programs. like personal care assistance, as well as other programs for individuals with intellectual disabilities, individuals who have various needs for hands-on support through potentially what's known as the Community First Choice Program, which is another federal program that states may offer that will provide payment for caregivers for individuals that have various support needs. Excuse me. So these Medicaid benefits are administered by both the federal and the state government, and very often have low income and low asset limits that need to be adhered to in order to maintain eligibility. So for example, in Connecticut, the asset limit for somebody that's receiving those Medicaid waiver services and supports, if they're not working, that asset limit is $1,600, meaning that they can't have more than $1,600 in their bank account from month to month as of the last day of each month in order to keep those benefits. So we need to look at what tools, what planning can be done so that the individual's benefits are not disrupted if there's family support monetarily through gifts or inheritances. So the legal tools that we're going to talk about to help protect benefit eligibility for these means tested benefits are ABLE accounts and third-party supplemental needs trusts. And again, both of these things are really governed by federal law, but understand that there are specific intricacies of each state that might vary the rules slightly. So first and foremost, ABLE accounts. An ABLE account is a tax-advantaged bank account for individuals with disabilities that is operated by the state's Department of Treasury. So basically, it's a state-operated bank account. I often would compare these ABLE accounts to college savings programs, 529 accounts. And actually, ABLE accounts are created under 529A of the Internal Revenue Code. So they have a lot of similarities to those traditional 529 educational savings accounts. And it has tax advantages in kind of that similar way. When I say that these accounts are operated by the state, that means that you can't go to the bank. You can't go to Bank of America and say, I'd like to open an ABLE account. There's a process that each state has established, typically a phone number or usually an online portal where you can go in and actually apply and set up an ABLE account. In order to qualify for an ABLE account, an individual must have had a disability that started prior to the age of 26, or in 2026, it's going to bump up to the age of 46. So there is that age-related requirement. The disability requirement is disability as defined by Social Security. So in essence, that is a disability that's impacting your ability to work, that's expected to either result in someone's death or last 12 months or more. And that's really that definition from the SSI benefit that we were looking at a few slides ago. An ABLE account can be opened in virtually any state. So it's a federal law that basically says states, you can create these ABLE accounts within your state and you can open eligibility up to both residents and non-residents. So the state of Ohio was the first state to offer ABLE accounts, and everybody was kind of flooding to Ohio because the other states just simply hadn't pioneered their own program yet. So different states have their own programs. Some states actually work in a consortium of states. So there's regional states that are working together and offering essentially the same program. The ABLE account will have aligned features in terms of these rules that I'm going over. These rules are set up by federal law. The things that are going to differ state to state are potentially who the financial investment manager is. So for example, some states use Fidelity, some use Vanguard to manage the funds that are in the ABLE account. So that's going to differ. Things that differ based on bank accounts will also apply with ABLE accounts. So what is the minimum balance you have to carry? What are the fees that are potentially associated with the account? So things like that might be specific to your state. There also might be certain advantages to opening an ABLE account in your home state. So for example, excuse me, in Connecticut and in other states, but in Connecticut, there is, as of a couple of years ago, the ability to get a personal income tax deduction for contributions that are made to a state ABLE account, meaning that the state of residence, if you're opening it in your account. So if you're contributing to an Ohio bank account, but you're a Connecticut ABLE account, but you're a Connecticut resident, you're not going to get an income tax deduction on your personal tax return in Connecticut. The other possible advantage is, in general, and we'll talk about this a little more, but an ABLE account ends when the person with a disability passes away. And at that time, if there's any money left in the account, under the federal law, there's a payback to the state to pay the state back for Medicaid-based services that the individual received. So essentially, the state is the first beneficiary up to the amount of Medicaid benefits provided. Some states have waived their payback provision. So Connecticut just waived its payback provision. If a Connecticut resident is opening an Ohio account, Connecticut still has the right to go and recover their payback interest. So looking at and understanding what the certain advantages might be to your home state would be a helpful thing to ultimately do. An individual can only have one ABLE account. So it can't be that they have an ABLE account in Ohio and one in Connecticut. It's just limited to one ABLE account per person. If they want to move their ABLE account, they can do that. They can roll over the ABLE account from one state to another, but they can't have more than one. I am going to just see for a second. Let me see if I can stop sharing because I opened up. Just a moment. Let me see here. I opened up. Here we go. So this is, yes, you can see this. So this is the ABLE National Resource Center. And I had right on my slide the link to this website. If you're looking to learn more about ABLE accounts and you're looking to look at what's available in your state, or even if you're looking to compare states, this is a national resource that has information about all of the ABLE accounts in every single state. So Connecticut, you could go in and you can look at basically, does it accept out of state residents? What are contribution limits? What's the total account limit? They even have right here the Medicaid recovery status. So these are all things if you want to go and compare state to state. And then there's even, let's see if I can, yeah, right here. If you go under save, use the 3-state comparison tool. So if you want to compare Alaska to California to Connecticut, you can look at all of these varying features and help them to inform what state you may want to ultimately use. Okay, so we go back to the presentation. An ABLE account, this is who can open an ABLE account, and it's an order of priority, meaning you can't skip ahead. You have to go and look and see if there's an eligible person that's able to open the ABLE account, then that's where you have to start. So the individual with a disability, if they have capacity, then typically they would be the one to open the ABLE. If they don't, if they've named an agent under a power of attorney, they could open it. Next in line is a conservator or a guardian. Often the state is going to require that conservatorship or that guardianship include financial authority to be able to open the account. So kind of looking at understanding free of what scope of authority is involved is important. Spouse then, parent, sibling, grandparent, or lastly, a representative payee, which is somebody appointed through Social Security to manage someone's Social Security benefit on their behalf. So all of these individuals could potentially open an excuse me. An able account can hold contributions from any person. And it's just money. You can't put in stock. You can't have a bond at the able account. It's really just cash that's going to be sitting in cash or invested, depending on what parameters you set when the account is ultimately opened. There are annual contribution limits for the able account from all contributors. So if an individual sets up an able account and they put some of their own money in it, and the parent funds it, and now the grandparent wants to fund it, you have to make sure that all of those contributions are going to be within the annual contribution limit, which is $19,000 in 2025. That number matches the federal gifting permitted amount. So as you may hear, from your accountant or your own attorney, you can gift up to $19,000 per person per year. When that gifting number changes, the able account contribution limit will be the same and match that number. There's just a little note here that if the individual with a disability is employed, there are certain rules that permit them to contribute additional wages, typically if they're not enrolled in employer-sponsored retirement plan that the employer is contributing to, like a 401. The able account balance is capped at $100,000 for individuals enrolled in SSI. So that cash benefit program that we talked about, if they're enrolled in SSI and they have $101,000, whatever is over that limit is ultimately going to be counted as a resource. So the able account has to stay within that $100,000 so that the person doesn't go over their $2,000 asset limit for the SSI benefit. If someone's not on SSI, let's say that their SSI went away because they had a parent that retired and now they're on SSDI benefit, which doesn't have the $2,000 limit, that $100,000 is no longer the maximum. Now the maximum is going to be set by the state. And that maximum is typically going to match whatever that 529 account maximum is, like Connecticut, $300,000. So an able account can hold up to $300,000. Again, subject to the fact that it can only be funded in $19,000 annual income. So it's gonna, if you're opening your account tomorrow, you're only gonna get there $19,000 year to year. The money in an able account can be invested, as I mentioned, and it grows income tax, meaning there's no reportable income for the investment interest. And likewise, distributions, provided that the account distributions are proper and within the rules of the program, are also going to be tax-free. So it's an income tax advantage account. The able account, those rules as to how does the money have to be used, it has to be used for qualified disability expenses of the individual with a disability. Generally, the regulations are very broad and freeing in this regard, meaning virtually anything can be traced back to an individual's disability. So if an individual wants to go on vacation and buy their plane ticket, well, that's really good socially, and anybody's mental health is important regardless of what the underlying disability is. So that's going to be a disability expense. A cell phone, rent, food, gas. As long as the account typically is being used for that individual and not to take other people out to lunch, to buy a gift for somebody, then it's typically going to follow the rules of the account and not be subject to any penalties for those distributions. When the able account ends with the death of the person with the disability, anything remaining in the able account is going to get paid back to that state and Medicaid services, as we discussed, unless the state legislatively has waived that payback interest, as I was discussing, is the case in Connecticut. Okay, so that concludes the able account portion of the presentation. So in summary, an able account is used for the money of an individual with a disability or other individuals in life, parents, grandparents, siblings, whomever wants to provide monetary support. There's income tax advantages to that bank account. bank account's going to be opened in the state that you choose, whether it's your resident state or some other out-of-state able account. There are annual contribution limits so that from all sources, you can't exceed $19,000. So if an individual puts in $10,000, a grandparent cannot put in $19,000. They can only put in $9,000 because from all sources, when we add them all up, can't be more than $19,000. The account has to be used just for that individual. And then there's rules in terms of whether there's going to be a payback when that person dies if there's funds left in it. That's the kind of role that the ABLE account ultimately serves. Just to note, one of the nice things about that ABLE account, excuse me, it can be managed by other people, it can be managed by a parent or an authorized person, but it also could be managed by the person with the disability, meaning that that individual could have direct access to the funds, or at least to a portion of the funds, which is going to be different from special needs trust that we're going to talk about. And that direct access and control is part of why ABLE accounts really came about in the first place. ABLE actually stands for Achieving a Better Life Experience. And one of the principal proponents of the legislation federally had Down syndrome, and this young woman was talking about the unfairness inherent in her inability to control money due to her disability, because as we see with regard to special needs trusts, there's a separation between the individual and the person controlling the funds. So ABLE accounts fill that gap to a certain degree and allow the person some levels of access and control to their own funds. All right, so let's talk about third-party supplemental needs trusts. These, you may also hear these referred to as special needs trusts or supplemental. So there's some interchangeability in terms of how you'll hear about this document. Before I kind of delve into what this slide says, when we're talking about special needs trusts, there's in general 3 types of special needs trusts. So we're going to talk about the third-party trust because that's really what is relevant when we're talking about money from other people and when we're talking about inheritance or estate planning. First-party special needs trusts are different and distinguished because they hold the money of the individual with a disability. So if somebody receives a settlement due to medical malpractice, due to personal injury, if they received an inheritance direct, so somebody named that person with a disability as a direct beneficiary, as opposed to naming a third-party trust, then somebody might need to make their own money invisible, and that's through the use of a first-party trust. First-party trust is money that belongs to that individual with a disability that they received or had a legal right to. The third-party trust is we're going to talk about that holds money of other people. And then lastly, we're going to talk about a pooled trust, which we're not going to talk about it. What exists also is a pooled trust, which is a type of special needs trust, which is typically finds its use for people that are 65 or older that are qualified. The focus today is that third-party supplemental needs trust, but I wanted you to walk away understanding that there's other trusts out there. So if you're doing some further reading, not to be confused and think that you're necessarily reading about what we're about to discuss. So a third-party supplemental needs trust is a legal document that's going to hold property or money from someone other than a person with a disability, like parents or grandparents. So as I mentioned, it's a key tool for inheritance planning or gifting for a loved one with a disability. For people that maybe aren't familiar with trusts in general, trust I think is a very intimidating and chilling word where you can feel like you're confused already and think, I don't know what a trust is. So a trust is a bank account with rules kind of at its core, which basically means, so let's say, to kind of break things down, if you have a life insurance policy and you say you want your grandchild to be the beneficiary of that life insurance policy, but that grandchild has a disability, so you don't want it to go to them outright. You work with your financial advisor and your attorney to put a beneficiary designation on that life insurance policy that names let's say if your grandchild's name is Gabriel, instead of naming Gabriel as the beneficiary, it would say the trustee of the Gabriel Third Party Supplemental Needs Trust. And when you die, instead of Gabriel inheriting the money, the trustee, the person that's named in the document, is going to set up a bank account in the name of the trust that's going to receive that money. So essentially, the trust is going to be a bank account that's set up, funded with money, and there's rules, and we're going to go over the rules that attach to that. And the trust is the legal document that tells you about those, which is typically whose money is in, who control it, what happens to it, if and when that person passes away. The third party trust is created by someone other than the person with the disability. So that person is called the grantor or the settlor. This trust can be created by parents. It can be created by friends, siblings, grandparents, anyone other than the person with the disability. Unlike an ABLE account, an individual can have more than one third party special needs trust. So a parent might set one up, a grandparent might set one up, and the individual can receive and be the beneficiary of both of those trusts at the same time. Likewise, parents and grandparents can fund the same trust. So one trust can have multiple people and funding sources, or have separate trusts. And a lot of times that's just going to depend on the family circumstances, what are the terms of the trust, and whether they're in agreement with all of those varying details. The third party trust is going to hold money or property, and by property I mean real estate. So it could be possible for a trust to somebody to deed property into the name of the trust. So the trust can actually be the owner of a house, for example. It can be the owner of a business interest. It can be the owner of a car. So there's endless possibilities in terms of what can be owned in the name of the trust. It's going to hold the money or property of someone other than the person with the disability. So again, we're talking about inheritances and gifts. An individual with the disability may be the beneficiary of multiple trusts, as I just stated, and more than one person can contribute to the same. The third party trust is going to be managed by someone other than the person with disability, known as the trustee. And this is that real distinction between the ABLE account and the special needs trust, whereas the ABLE account could be controlled by the individual with disability. The third party trust cannot be, can never be. Even if the individual with a disability has cognitive capacity, that's really irrelevant. It's not the threshold for determining who can manage the money in the trust. The trustee can be a family member, it can be a friend, it can be a professional trustee. It can be more than one person. So sometimes there's two trustees acting at the same time. Sometimes those trustees need to agree on everything, need to act together. And other times trustees can act independent of each other, meaning either person can go to the bank, either person can make a decision. And a trust can have a succession of as many trustees as you want, and having or naming someone at a higher generational level, naming nieces or nephews or grandchildren or siblings as contingent beneficiaries, or a professional trustee, just to make sure that there's going to be some continuity. So as the individual ages, they're not going to get to a point where all the trustees are 20 or 30 years older and really aren't functionally able to serve in that role as the individual may need. One of the key tenets of a third-party trust is that that person acting as trustee has sole, absolute, and uncontrolled discretion to say yes or no to a distribution. One of the ways that I would think about this is if you think about a third-party trust as a pocket with money in it, the trustee can put their hand in the pocket and give the money to the person with the disability or spend it for their benefit. Go and purchase things on Amazon, go buy the paint, go pay for the rent or whatever the payment for the distribution is. The trustee can take the money out of their own pocket and make those payments. But the person with a disability cannot put their hand in the trustee's pocket. Because if they had some right to compel a distribution, meaning to force the trustee's hand to have direct access to that money, well, then the state or the federal government is basically going to treat that trust as if it belongs to the person with the disability. And all of those invisibility properties that make the money invisible for benefits are going to go away. And the whole purpose of the trust is going to be trust. And it's not going to work as a special needs trust. So the distribution standard of special needs trust is the pure discretion of the trustee, meaning that if the beneficiary wants money, the trustee has the ability to say yes or the ability to say no. And as disgruntled as the beneficiary may be at the trustee's decision, they don't have legal rights to compel the distribution. If they did, it would be treated like they're grabbing the money themselves, and the trust isn't going to work as an. And those distributions from the trust have to be for the sole or the primary benefit of the person with it. There's varying levels of flexibility as to these distributions, meaning often a distribution for an individual, let's say that has a disability, but they can't go on vacation themselves. They're going to need, because of their disability, a support person. The trust often has a level of flexibility to pay for the individual as well as a companion or a caregiver from the trust without running afoul of that rule in terms of the sole or primary benefit of the funds. But again, that's something that should always be looked at. A trust could include something called a trust advisory committee. This is something that I typically recommend when there's maybe not a family member serving as a trustee. So sometimes, for example, families say, well, we just don't know who we would name, everybody's older, or we just don't have that definite family to really know who could be a trustee. Or it's just really not appropriate to name a sibling, for example, as trustee, because a sibling is a sibling, and you'll alter that dynamic naturally with giving them financial control, giving one financial control over the other. It creates a business dynamic and a control, an imbalance of power dynamic that could be undesirable. A trust advisory committee, in my opinion, is a nice way to balance that out, in that you can name one or more people, family members, friends, professionals, like a social worker or a therapist, that ultimately inform and advise the trustee in terms of how they think the trust could or should benefit the individual. They don't have the authority over the money directly to make the decisions, but they're acting in an advisory capacity. And they can also be acting in a review capacity. Trustee can give them financial reports so that they can make sure the trustees do their job. Depending on how the document is drafted, they might have the ability to remove a trustee by vote. It all depends on what the trust language ultimately directs, but they might have the ability to remove a trustee, or they might just have the ability to bring concerns to a local court to review the activity of the trustee. Likewise, the trust can include what's known as a trust protector. So instead of having a group of people, you can name one person that has that review authority to make sure that the trustee is doing a good job. Sometimes a trust protector also has special powers to defend the trust, so the trust is set up so it's irrevocable. If there's changes in laws or if there's changes that ultimately change how the trust was used, the trust protector might be able to come in and make some changes to the trust language so that it continues to be intended purpose. A third-party trust can be created under a will. If a trust is created under somebody's will, it would basically be, let's say, Article 2 of the trust says 100% of the rest of my estate is going to go to the trustee of Gabriel's third-party trust, as set up under Article 3. Then we look at Article 3, and Article 3 basically says who's the trustee. It has all that special language about the trustee having discretionary authority to use the money for Gabriel. And then it's going to say when Gabriel's trust ends, this is where the money is going to go. So these other named beneficiaries. When a trust is created in a will, it's overseen by the probate court, really for the life of the trust, meaning that the trustee is going to have reporting requirements to the court in terms of accounting as to how the trust money is being used. By contrast, you could set up a third-party trust as its own document, meaning it's its own separate document, or maybe if somebody has their own revocable standalone living trust, we could have sub-trust within that trust. That's a third-party special needs trust. In either of those instances, the trust is not by default overseen by the probate court. Usually in those cases, that trust would only come with the probate court supervision if someone raised a question or a concern as to whether the trustee was really doing the job. But otherwise, it's set up without the need to do that reporting to a court. And those trusts can be revocable, or they can be irrevocable, meaning they can be undone, or they can be set up so that the terms are set in stone from when it's set. When a third-party trust ends, there's no payback to the state, meaning that this trust holds money or property from other people. So not the person with the disability, it holds an inheritance or it holds a gift. And for that reason, because the person with the disability never had the right to access or control or compel a distribution from the trust, the state, who's essentially a creditor of that individual, also doesn't have the right to compel those distributions or to compel repayment for services provided. So when you set up this trust, you see other people as the remainder beneficiaries. So when the trust ends, which is typically when the individual passes away, if there's anything left, maybe the children, maybe they're named as beneficiaries of whatever's left, siblings or whoever, charities, whatever it may be. And that concludes my presentation. So the third-party trust, just to kind of put a button on it and summarize, is going to be used as an inheritance planning tool. There are no contribution limits, so we're not capped at that $18,000 a year. It can be funded by anyone other than the person with a disability, created by anyone other than the person with a disability, and be controlled by anybody other than the person with the disability for that individual's benefit. And then when that trust ends, the remainder beneficiaries are named by the person who created the trust. Able accounts and special needs trusts, they're not mutually exclusive. You can have an able account and you can have a third-party trust, because I think as you can kind of see, one does not necessarily serve the same purpose as another. You can't name an able account for an inheritance because you're going to blow past that $19,000 limit. And you're not going to be able to protect that full inheritance. So an able account might be a tool that individual has own money and maybe some gifts and some support throughout the years, whereas a third-party trust is really that larger, more lifelong inheritance planning tool. So it's really based on what are the needs of your family and how you ultimately structure it would be based upon what those needs are, and obviously in consultation with a local attorney that can best guide you in terms of how to make all these legal tools merge and work together as best they can. I'm happy to answer any questions. I know I've seen some things in
Yes.
the chat.
Okay. Thank you, Kathleen. That was amazing.
Oh, good.
Uh,
You're very welcome.
We do have some questions, so I'm just going to kind of go in order, and then I'll open it up to people just, raise their hands. Okay, so Sarah asked, do you have to be on Medicaid to have an ABLE account?
No, you have to have a disability based on Social Security's criteria. So the two ways to really substantiate that are you're either on Social Security, meaning you're getting SSI, you're getting SSDI, or there's an alternative route where you can essentially have a physician fill out a certification form saying that you satisfy that criteria. And I think if you go on that national website that I gave you the link to, there's a sample form that you can find there. Basically, it's a self-certification form. You don't have to file it anywhere. It's essentially, you're going to keep that in case, I guess, if the IRS were to ever audit somebody and say, were you eligible for this account? you'd have that self-certification.
Great, thank you. Tim asked, so if the individual with a disability is gainfully employed, but can only work part-time, say 20 hours a week, can they still benefit from an ABLE account in some way, or would it create over income for Medicaid and or SSI?
Can work and have an ABLE account. So the ABLE account is going to make your assets invisible for the purposes of qualifying for SSI or Medicaid. So if you're earning, let's say you're earning $500 a month, if you're on SSI, well, let's make it a little simple. If you're earning $1,000 a month and you're keeping that money in your bank account, in month 3, you're going to have $3,000 in your bank. That's going to put you over the $2,000 asset limit for SSI. So that person might want to take their $1,000 of wages and put them into ABLE account so that they're able to keep the benefit.
I was just going to say, sorry to interrupt, but I have a daughter who's 27 years old with CAC-1A, and she works, and her paycheck, just like when anyone works and your paycheck goes into your bank account, her bank account is her ABLE account. So all of her money just flows directly into her ABLE account, and then she has a debit card associated with her ABLE account that she just uses like it's a bank account, and that's how we do it.
It's a beautiful thing when it works that way. Yes.
Nice. Can an individual receive Social Security income benefit at any age?
Yes, you can. So let me just clarify. So prior to the age of 18, it's going to be hard to qualify for SSI depending on a family's overall resources. So that $2,000 limit is going to include the resources of parents for a child, because parental resources are deemed to a child when you're under the age of 18. At the age of 18, that's typically when people apply for the SSI benefit, because then there's a separation of parental resources and individual resources. So they're only going to look at that individual's bank. So yes, you can apply at any age, but typically you're not going to readily qualify due to that deeming prior to the age of 18. As an individual ages, depending upon parents retiring, being disabled, or passing away, it's possible that that SSI benefit will be replaced by an SSDI benefit, but it's not required. So some people, and it doesn't happen in every case. You know, some people have parents that never paid into Social Security because they're teachers. So they might be on an SSI benefit for their lifetime, and if there's no upper age limit, ultimately.
Thank you.
Mm-hmm.
So can you transfer or sell your house to a third-party trust?
Yes, I think so. Sometimes I work with families that we're talking about housing, and we're talking about what is the plan long term, where is your loved one going to live, and they say, well, I want to buy a condo for them, or I want them to live in our house when they pass away because it's accessible to them, and we'll also make sure there's enough money in the trust to pay for the upkeep of the house. So in that case, you can either transfer that property, deed that property into the trust during your lifetime, or what's the more typical route is that a parent will purchase and own that property, and then when they pass away, their estate planning documents are going to direct that property into the trust directly, and then there will be a deed transfer done, and then that's essentially how the trust becomes the owner of that real estate.
Could an ABLE account or third-party trust be targets of a lawsuit?
So I guess I'd have to look into an ABLE account. A third-party trust, probably not. It's going to it depends on how the trust is drafted, but usually they're drafted so that they're called spendthrift trusts. A spendthrift trust is a trust that has creditor protection to it. So, I mean, the idea is kind of like what I had mentioned earlier in terms of if the state of Connecticut can't have more rights than the beneficiary, and the same extends to a creditor. So if I'm the beneficiary of a special needs trust and I have a creditor, my creditor can't go after the money in the trust because I can't go after the money in the trust. So a creditor can't have greater rights than a beneficiary. So the kind of general answer is no, but you have to make sure specifically that all the right language is in place to keep those.
Great, thank you. Lisa, I'll come back to your question, but Robert asked, is there a time expiration to these programs or a periodic review of qualification status of the individual? What if there is a healing progress in the individual who these accounts were established? Can they unwind these if they no longer need the funds?
So for a third-party trust, there isn't actually any kind of threshold disability requirement. So you don't have to be a person with a social security disability or any other kind of medical impairment that's verified through social security or other medical records to have this trust. So it's not, there's no fact check there, basically. You can set up a third-party trust for someone that you suspect is going to have a disability, but that might not be diagnosed or you might not know. So there's not going to be a review for the third-party trust in terms of do you still qualify for it. For an ABLE account, you have to have had the disability at the time that you created the account. I would have to check the regulations as to whether if you lose your disability status, it can no longer further contribute to the account. My sense is no. My sense is if you qualified at the time of opening, you can continue to qualify. I would have to check the regulations, though I don't know that. I think the greater question is there an ongoing review period for the underlying benefits that you're using? The answer to that would be yes. Social security benefits are subject potentially to continuing medical review. And the same would be true, I guess, for Medicaid benefits, generally speaking. I think generally for Medicaid, you just have to keep maintaining your income and asset limits. I don't, although there might be some requirement depending on the type of Medicaid you receive that your underlying disability be on. So it's a bit state specific in that sense as well.
Lisa, do you want to ask your question? Are you still there?
Yeah, sure. Thank you. So I had a question about, so I have a daughter, as I mentioned, and she gets SSI, and she's working now. So how many, in order to switch from SSI to SSDI, and you're obviously in our community, all of our kids will have their disability will have started before the age of 21. So in order to switch, you need 6 work credits within 3 years. Is that correct?
I'm not an expert on that. So there's some good social security resources that you probably reference, little red books and things like that. I don't actually do the social security applications. It sounds right to me. It's age dependent as well in terms of how many work credits you need within a certain number of years prior to the application. One of the things I would do, so two possible resources. One is you can always call your social security office and just say, the situation, she's been working, presuming of course you've been reporting wages and things like that, because those wages are obviously affecting the benefits she gets every month. So you can call them or make an appointment to review that. And you could also go on to myssa.gov.
A certain type of life insurance that my husband and myself should take so we can make sure our child with intellectual and developmental disabilities has funds available after we are gone, as he will need lifelong care.
I would say work with a financial advisor to determine that. And there are financial advisors that are certified special needs planners. There's a specific designation. So if you can find one of those locally, that would be ideal, because they can kind of run those projections. They can look at your private resources. They can look at what the individual's needs are. and where the gap is, and then identify what the best maybe financial products or insurance products are to fund a trust. One of the most common insurance policies I see is like a second to die whole life policy. So parents maybe buy a $1 million life insurance policy that pays out when the second parent dies. Term policies are often less expensive, but the problems with term policies are that they're term. So if you outlive the term, the policy goes away. So if you really need to know that those funds are there because you're relying upon that, then that might not be the best fit, but I would recommend working with an advisor to really look at those options. And you know, certainly keep asking the questions. I can go through whatever's left.
Okay.
I think there was a couple more questions.
Yes.
If you have a few minutes, that I think would be interesting.
Okay. Carissa had asked about Lisa's statement about, can't she get $20 an hour to go straight to her ABLE account? Like when Lisa, when you said your daughter, you
No.
needed her to make less.
So let me just
So-
be clear about that. I think the question is, in terms of the income limit, so the problem is an ABLE account is going to make your assets invisible. It's not going to make your income invisible. So you can't just earn a bunch of money over and above the Social Security limits and direct it to your ABLE account and make it invisible. It doesn't work that way for income. So certain income limits can't be subverted with the use of an ABLE.
Okay, those are all the ones in the chat. Does anybody have a question in the group that they've been sort of thinking about and want to ask? Okay, no one raised their hand, so
I have a
Kathleen.
quick question.
Yeah, okay.
I have a son with an intellectual disability, and I have found that he's so socially high functioning, but his intellectual disability like gets in the way of him receiving a lot of services because he can go to the bathroom himself, he can ride public transport by himself. So I'm just curious from your experience, like, are there certain ways of describing or getting, is there certain language that are really helpful for our families to receive the SSI? Because we are like right on the cusp of getting any benefits because we are like not too disabled, but we're definitely not high functioning. And so we barely meet any of the disability markers, but we will because we have a progressive condition.
That's really a question for your local special needs attorney to guide you. So from a Social Security perspective, they're going to look at medical records, educational records, things that you provide to demonstrate whether they meet they have what are known as listings, which are basically general descriptions of if you meet all of this criteria, then we find that you have a disability that meets Social Security's definition. So you know, that's going to be how Social Security, the lens that they look at it through. Different state-based programs have different criteria. So like, for example, in Connecticut, people with intellectual disabilities are served by the Connecticut Department of Developmental Services. We define that different from how Social Security is going to define disability. So we look at, do you have an IQ, excuse me, of 69 or less, coupled with adaptive deficits, essentially. So some people don't meet that definition, some people do. There's other programs that don't necessarily look at your cognitive IQ, but they're looking more at your adaptive abilities. Like Community First Choice is a program that I referenced that just looks not at your IQ, but they look more universally at what do you need? And sometimes those needs are hands-on needs, but other times are there barriers to independence. So I have a lot of families of kids like with autism that, similar to your child, are very functional in terms of they can dress themselves, they can bathe themselves, but you know, socially they're not able to get a job. They might have some limited skills in terms of independent living, so they're going to need some in-home supports. So that program looks more holistically, less at a label and more at what are your functional needs. So those are all the types of things that with a local special needs attorney, they can help you to determine what's available, and what definitions you may meet today and may meet in the future.
Excellent. Sarah, I'm gonna send out the presentation to everyone who is here today. And so that website that she said with the state specific resources for able accounts will be in that presentation. Anybody else have a question?
I have just one more. I hope you don't mind.
Go
Um,
ahead.
I've never heard of a special needs attorney. And because we are all rare disease, right? Like specialty, are there distinctions amongst special needs attorneys that would be helpful for us to know about? Qualifications or certifications that would make one more appropriate for us than others?
I would look for an attorney that says that they do special needs planning and that does special needs trusts. I don't think that somebody has to have specific experience with CACNA 1A to be able to help you. I certainly don't have experience with this disability, but all of the same premises are true. So essentially what you're looking at is understanding what the needs are, understanding what the benefits are, and then trying to come up with a plan. Special needs trusts are just going to come into play and say whatever benefits you're on or you may be on, let's make sure we protect them through the use of trust planning. Not all estate planning attorneys are going to be special needs planning professionals to the extent that they might not draft special needs trust as a regular course of business, and they might not have familiarity with public benefit planning. One resource that I would recommend to you would be there's two organizations that are national that have find an attorney tools to them. One is called the Academy of Special Needs Planners, ASNAP, and you can Google Academy of Special Needs Planners, and they have a find an attorney tool in your state. So you can put it in and it will come up with people in your state that are members of the Academy of Special Needs Planners. And then you can go look at their websites and get more information, obviously meet with them. But if they're a member of that organization, they're more likely to really focus on it in their practice. The other resource is called NALA, which is the National Academy of Elder Law Attorneys. Elder law often encompasses special needs, and the reason for that is because the foundation of a lot of elder law planning is public benefits and Medicaid. So within NALA, there's many attorneys that focus on special needs planning. So you could go to their find an attorney tool as well and start to kind of investigate and see who might be a good fit. But certainly I would go to an attorney that really right on their website, they talk about special needs.
That is so helpful. Thank you.
You're welcome.
Anyone else have a question? Waiver, individual automatically be qualified to open an ABLE account at any age in order to hide assets and yet still qualify for Medicaid.
So Medicaid is not the threshold for an ABLE account. It's whether you have a disability that meets Social Security's criteria. You had to have had a disability that started before the age of 26. 46 in 2026, the age limit's going to go up. So you can't have a disability onset at 30 right now and qualify for an ABLE account. Right, and just to reiterate, it's not being enrolled in a Medicaid waiver is not the criteria or threshold for the ABLE account.
Okay. Well, thank you, Kathleen. I want to be mindful of your time. We so appreciate you taking the time to speak to our community.
My
And I
pleasure.
know this is very helpful for me, and I'm sure the rest of us on the call. There's been lots of thank yous. Thank you. I love this
Oh,
in
you're
the
welcome.
chat. And everybody has said how fabulous it is. And so
Good.
we will get this recording uploaded and onto our website. And Kathleen, I think you wanted a link to that too once we
Great,
did
I'd be
that.
happy to put it on mine as well. Yeah.
Yeah.
And thank you all for the beautiful flowers. I truly appreciate that. It was unnecessary, but it will brighten my weekend. So thank you very much.